Good morning, and thank you everyone who's joined me for this webinar. The No5 marketing team have informed me that over 250 people have signed up to it, which is really good news. My name is Stephen Goodfellow, and I'm a barrister at No5 Chambers. I've been practicing for over 20 years in civil litigation, and I have a special interest in the CPR, including relief from sanctions and cost issues. This webinar will be valuable to all litigation practitioners who will inevitably find themselves dealing with cost budgets, relief from sanctions applications, and Part 36 offers, amongst other matters. Due to the number of people viewing the webinar today, may I ask you to use the chat box if you have any technical difficulties. Also, I will deal with all questions at the end. So if you think of any questions during this webinar, please feel free to submit them using the Q&A function during the webinar. Then we can hopefully discuss and consider the questions at the end. Hopefully you'll all receive a copy of my slides. If not, don't worry. I'll refer to the slides and the case names as I go through so that you can cross-reference them later if you need to. So if we begin, looking now at the second slide in my PowerPoint, I'm going to be looking at, first of all, important developments in cost budgets. Now, the first ones we're looking at are CPR and practice directions. I have to say the White Book is not particularly helpful with the new CPR updates that came in October of this last year. As you have to navigate between the original White Book and the new update. And it's helpful sometimes to look at it all in one place. And you could do that actually on the government website where they already updated and incorporated the new CPR into it. So what's the changes in CPR? Well, the important points of CPR for cost budgeting is at 315. In particular, there's new sections at 315.5 to 8. And this information relates to the precedent H and costs that can be incurred in the next respect of that phase. Now, those of you who are familiar with the practice directions will know that, in fact, a lot of this has come from the practice directions 3E, which dealt with cost budgets. So, for example, 315.5 used to be old practice direction 7.2, 315.6 was old practice direction 7.5. Now, another perhaps more important addition to the CPR is at 315A, and this deals with variation of cost budgets, which was actually found originally in practice direction 7.6. So what they've done here is they've moved it into the main CPR to make it more apparent and to try and ensure that it is followed more. There's also been a subtle change in the wording. Originally in the practice direction, it said that each party shall revise its budget, whilst now in the CPR at 315A, it says a party must revise its budgeted costs. Now, obviously, this is still mandatory, but obviously, I think it's trying to encourage practitioners, encourage solicitors to ensure that they do vary their costs. And the position where they have to vary their costs is if there's been significant developments in litigation that warrant such. So it's significant developments. Now, also then looking at the new practice direction 3E, which deals with the cost budgeting, this has been expanded. Originally in the old version, it was about 2 pages of the White Book, whereas now if you look it up in the supplement, you'll see that it comprises some 4 pages. There's a lot more detail there. So for example, at paragraph 10, there's a helpful assumptions table as to what should be included and what should not be included in the different phases of the precedent H. For example, if we look at the trial preparation phase and you look across to the 3rd column, which is the not included, you'll see that it says there that assembling and copying a bundle is not included. Now, obviously, it's very frequently asked within that phase to cover the cost of that, and judges always say no, that's not actually allowed within the phase. So again, it's helpful there just to point out to practitioners more clearly what should be included and not included. There is also an interesting reference in paragraph 13 to oppressive behaviour. It allows one party to make an application to the court if they think there's oppressive behaviour by the other party, forcing them to incur a high level of costs. Now, it'll be interesting to see how that develops and what the case law is on that. And finally, perhaps most importantly, in Appendix C of the new Practice Direction 3E, there is the new Preston H. Now, this is what was going to have to be used by practitioners to apply to revise, amend their budget. This form is a fairly simple form. It's very similar, I suppose, in layout to the Preston R and indeed the Preston H. You've got your broken down into all the separate phases. There's a column dealing with all the existing budgeted costs, incurred and estimated, and then there are new columns on the right-hand side setting out the variations. And so it should be very easy for the court to see the variations, the additional work being claimed for in each of the phases. Well, what is the practical effect of this? The practical effect is that it's really increasing, encouraging parties to vary the budgets. The courts are clearly going to enforce much more rigorously revisions of budgets where there's been a significant development. And the courts will expect you to have made the application during the proceedings. If you apply, for example, for further expert evidence, an additional expert, or you want to add in further witness statements of fact, which might maybe increase the trial period, then the court will expect you to put in a Preston T showing the increased budget. And indeed, at the time that you make your application for new expert evidence, the court will expect you to put in a Preston T. So it's quite clear to the court what the increased costs are for the extra direction case management that you're seeking. What you're not going to be allowed to do, which still happens a great deal at the moment, is to wait until detailed assessment and then say, under CPR 318, that you have a good reason for departing from the original budget. Because there's what the court will expect now is that you will have made an application beforehand for the significant development. And you're likely to find the judge saying at detailed assessment that if you've not made an application, then they will hold that against you. And indeed, there may not be good reason to depart. This doesn't mean, obviously, that the argument of good reason is no longer valid. Certainly, if you're a defendant, you may want to argue for good reason to depart from the original budget, because you may want to argue that there ought to be a reduction on the budget on grounds of proportionality, for example. That would be the case of Harrison versus University Hospital, a well-known 2017 case. Or equally, you may want to argue that there's a good reason to depart from the budget where not all the work has been carried out in the different phases. Again, that's the case of Bart's Health NHS Trust versus Salmon, a 2019 case. So whilst the argument for good reason to depart from the budget will still apply, that will often apply a lot more afterwards. And for changes that occur during litigation, the court will expect you to make an application to vary under 315A and using Preston T. Right, moving on to the next slide now. This is slide 4 in the matter. This is dealing with cost cases. And what I've done here is just try to split them into different areas. So we'll look at first cost cases regarding budgeting, then recovery of costs, and then QOCs. Now, with regard to cost budgeting, there has been one particularly interesting case last year that I've come across a number of times in court. I've had it cited in front of the judge as justification for not making an application for relief from sanctions. So it's being used where a party has put in their cost budget late and they're trying to argue to the court that they didn't need to apply for relief using this case. Now, this case is the case of Manchester Shipping Limited versus Balfour Shipping Limited. It's a 2020 case, obviously it's a High Court case. It's before Lionel Percy QC, sitting as a deputy judge in the High Court. Now, what was found in this case was that it's not necessary in every case for a defaulting party to make an application under CPR 3.9. And what he held was that they may instead invoke the unless provisions under CPR 314. That's at paragraph 7 of the judgment. Now, I think there needs to be a big health warning issue with this, because obviously on the, just a quick glance, is basically suggesting that you can use 314 instead of CPR 3.9, but it is quite particular to the facts. So I think it's worthwhile just looking at the facts in this case. In this case, the parties had agreed a very detailed, I think 19 steps that they were going to follow in the procedures leading up to the CCMC. And these 19 steps that they'd agreed between them made no mention of cost budgeting. And what happened in this case is that the claimant filed a cost budget on the 24th of December. Quite a good tactical move, you might say, filing it just before everyone leaves for Christmas. And consequently, the defendant actually didn't realise and file its own cost budget until the 9th of January. So the defendant was 13 days late, but there were still 8 days before the CCMC. And when they filed it, the claimant said that it reserved its position. So it didn't object outright, it just said it reserved its position. And the defendant stated that it would raise the matter at the CCMC, that it believed it had complied with their agreed directions, and that if C maintained that it was in breach, it would make an application at the CCMC. Now, at the CCMC, the claimant then argued that it was incumbent on the defaulting party to apply under CPR 3.9. But the judge held that actually it was not necessary in every case. Otherwise, it would be contrary to CPR 314, and it would make 314 irrelevant and redundant. Obviously, what 314 says is that unless the court orders otherwise, a party may be restricted to court fees. So the judge used that and said he was entitled to use his discretion when deciding whether to allow a relief, which he did. It's interesting to know that in that case, he still applied the test in Denton versus White, whilst it's a three-stage test, which is whether there's been a significant breach, whether there's good reason for that breach, and whether it be equitable in all the circumstances to grant relief. So we're going to come back to that later, but I will say at this point it would not be wise to rely too heavily on this case. The next case I thought I'd mention, this is now on slide 5, is the case of Herbert versus HH Law Limited. It's a Court of Appeal case from last year, with a decision by Sir Terence Etherton, Master of the Rolls, as he then was. Now, this deals with recovery of success fees. And what happened in this case was that a solicitor's firm had a uniform 100% success fee, which they charged to all their clients in personal injury claims. And in this case, the client had brought an action under Section 70 of the Solicitors Act 1984, disputing parts of the bill. I have to say there's an increasing amount of these applications now being made. It seems to be a new form of satellite litigation, with clients much more ready to challenge their own solicitors' costs and bring these assessments under the Solicitors Act. But equally, though, the other side could potentially challenge the level of success fee. So this has lots of applications. Now, in response to the challenge, the solicitor said actually that it was necessary to have a 100% success fee. It was necessary to recover the overheads and maintain a reasonable profit for the firm. And this judge had to consider, this was under CPR 46.93, when considering the reasonableness or unreasonableness of costs between a client and solicitor. You had to consider under A, costs would be reasonably incurred if they were incurred with express or implied approval. Meanwhile, under 46.93C, costs are unreasonably incurred if they are of an unusual nature or amount, and the solicitor did not tell the client that they would not be recoverable from the other party. So in this instance, the district judge was quite critical of the fact that there was no risk assessment. And he said there was no risk assessment which would justify a 100% uplift. He actually went on to say that in this sort of case, a success fee of 12.5% would be more appropriate, where it was fairly straightforward, there was no time of work, it was likely to settle in a short period of time. He actually was a little bit more generous in the end, and he allowed a success fee of 15%. Now, the Court of Appeal, when they considered this, equally agreed that a success fee could be irrecoverable if it was of an unusual nature or amount, and therefore the issue to be determined in deciding whether or not the solicitor could recover it was whether the claimant had expressly or impliedly agreed to it. That's in paragraph 35 of the judgment. And what they found, the Court of Appeal, is that as the solicitor had not told the claimant that the 100% success fee took no account of the risks of this individual case and was just a blanket success fee, then the client did not have informed consent. And so therefore it was not recoverable and the 15% was applied. Now, what is interesting in this actually is I didn't say it would be wrong to charge a blanket 100% success fee. So it's quite possible potentially for a solicitor to have a 100% success fee for all cases, providing they tell the client, make it clear to them that this is not particular to their case, it's not fact specific, and this is just a general procedure they have. This case actually also considered whether HE premiums were solicitor disbursement, but I'm not going to deal with that today. The next interesting case I'm going to deal with is that of Morrow versus Shrewsbury Rugby Union Football Club. That's another 2020 case. It's a High Court case, and it was in front of Mr. Justice Farby. Now, this is interesting because it deals with the issue of exaggeration and what costs can be recovered there. Now, the judge was very clear in this case. There was no doubt that there'd been exaggeration of the claim for loss of earnings. He set that out in paragraph 30 of his judgment. But the claimant was not dishonest, because what the judge found was that he had a psychiatric condition, which meant he was prone to exaggeration and prone to pursue a case that was beyond common sense and was not what realism dictated. So in this case, the claimant had claimed over £1 million. He'd put in a Part 36 offer for some £800,000, although only shortly before the trial, whilst the defendant had made a Part 36 offer of £110,000. In the end, the claimant was awarded £285,000. So he still beat the defendant's Part 36 offer. Now, this is not a case where there's dishonest personal injury, dishonest exaggeration. So those of you who do personal injury clinical negligence will be aware, therefore Section 57 of the Criminal Justice and Courts Act 2015 will not apply here. Obviously, where that does apply, where there has been dishonest exaggeration, and obviously defendants can seek to dismiss claims and indeed seek to recover their costs from the claimant. So what happened in this case, and what indeed should happen? Well, the court considered that the defendant could have protected themselves with a better Part 36 offer. That is the purpose of it. So if they'd made a higher one, or say 300,000, they would have been protected. But still, the court said that there had been exaggeration and inflation of the claim, and it was built into the claim, in the witness evidence, in the expert evidence, the multiple days in court. And I think the word used in this case was that the exaggeration was ingrained. And they found that the claimant's conduct had caused unnecessary expense. Therefore, as a matter of justice, they ought to reduce the award of costs. And they looked at this by deciding how much extra time had been spent. So it was said that there'd been a prolonged trial, increased cross-examination, and that a 15% reduction was broadly appropriate to mark the additional costs caused. And you can find this in paragraphs 35 to 37. So the effect of this really is just confirming what is already there in CPR 4424, which is that when deciding what order to make about costs, the court will have regard to all of the circumstances, including the conduct of the parties. And at 4425B, it is very quite clear there that the conduct of the parties does include exaggeration of claims. So this case confirms the previous Court of Appeal case. It's an older one, 2009, Adelaide versus BAA, which said that when you're looking at the effect of exaggeration, you look at it in a causative way and try and look at the extent to which it's incurred wasted costs. So this will be useful for defendants to try and argue down and reduce the amount of costs, and it gives a helpful indication of perhaps 15% reduction where there has been substantial exaggeration. Moving to slide number 6 now on my PowerPoint, looking at the case of Ho versus Adelaide. Now, obviously, this relates more to quox, so it's more interest to the personal injury and clinical negligence side of matters. But as it's such an important case, I thought I ought to deal with it in this. The leading judgment in this case is from Lord Justice Newey. You are probably aware of it, I'm sure, all by now. It deals with whether or not CPR 4414 bars defendants from being able to set off their costs against the claimant's cost orders. Now, in this case, the Court of Appeal decided that the earlier case of Howe versus MIB number 2, which was a 2017 case, not particularly widely reported, actually, they decided that that judgment was binding on them. But they said, and this is an interesting point, that if it was not binding, they'd be inclined to accept the claimant's submissions. That's in paragraph 15 of the judgment. And they would be inclined to say that a defendant could only offset their costs against the claimant's damages and interest. So the court went on to hold that, obviously, in this case, because of Howe versus MIB, the court did have jurisdiction to order the defendant's costs to be offset against the claimant's costs. But they did grant permission to appeal to the Supreme Court, and indeed they suggested that the Civil Procedure Rules Committee may wish to consider whether cost set-off should be possible in a quox case. And that they also say, actually, further down in the judgment, paragraph 43, I think it is, that this was a powerful case for calling into question the earlier Court of Appeal decision in Howe versus MIB. So the result of this is that currently the defendant can offset their costs against the claimant's costs under quox, but it is quite likely, I think, in my view, that this will end up being changed. So now if we move on to part 36, and this is slide 7 in the PowerPoint if you have it. Interesting case here, which I'd like to refer to first, is that of MR versus Commissioner of the Police for Metropolis. Again, this is a 2019 High Court case in which Mrs. Justice McGowan decided that an offer for nil damages can be considered genuine. Well, this is quite a striking headline when you first look at it. So it's important actually to look at the facts in this case to see how applicable it is generally. Now, the claimant in this case was well known in financial circles, and he was arrested on suspicion of offence of harassment, but he was released without charge. He then brought a claim for, amongst other things, false imprisonment and assault. And the defendant made a Part 36 offer for £4,000 in damages and a draft letter of apology which expressed regret, but did not importantly admit liability and admit that there had been false imprisonment. Now, the claimant rejected this offer, and part of the argument was that it's important for him, as he travelled around a lot and went to other countries, including America, that he had to disclose on entry to these countries that he'd been arrested, and this would cause him substantial difficulties. The claimant himself made a number of offers, but the important one in this case was an offer he made for nil damages and an admission of liability together with his reasonable costs. At the trial, he was successful on the claims for unlawful arrest and for damages, and he was awarded £2,750. Obviously, this was less than the defendant's offer of £4,000, and the judge made no order for costs. On appeal to the High Court, it was decided actually that he should be entitled to his costs after the Part 36 offer for nil damages. And because, and this is what was said at paragraph 18, giving up all and any claim to financial remedy is a significant concession and therefore a genuine Part 36 offer. Now, I'm going to discuss later the practical effects of that, but obviously just thinking about that, that potentially has serious, wide-ranging ramifications. The other case I'd like to refer to with Part 36 offers is DSN versus Blackpool Football Club. Again, 2020 case. It was a High Court case. And in this one, the claimant had succeeded in trial. They had beaten their Part 36 offer. And they sought indemnity costs, but they sought it for a longer period than they would normally under CPR 3617 4B, which deals with that. And the reason why they sought a longer period starting earlier in time was because of the defendant's failure to engage in mediation, necessitating the trial. And the judge held that the reasons for refusing the mediation by the defendant, which was that they had a strong case, were inadequate. Quite clearly, they'd actually lost a case, so they got that wrong. And the judge felt that they should have engaged in mediation, or they might have realised the weakness of their case. So what happened is that the judge actually awarded indemnity costs from an earlier period in time, from 1 month after the order required parties consider ADR. Now, this is actually a fairly standard term, which is seen in most orders nowadays, often very up near one of the first orders at the CCMC. And so that's a decision that they should have complied with that term in the original order. And so indemnity costs started from much earlier on. Interestingly, the defendant also actually cross-objected to indemnity costs, but they were objecting to the claimant having indemnity costs because the basis that the claimant had been awarded much less damages than they claimed on the claim form. And they were saying that it wouldn't be just therefore to award indemnity costs, because on a detailed assessment of indemnity costs, the issue of proportionality is not considered. And obviously they wanted to argue that the cost budget was done at a time when the claim was thought to be worth a lot more than what they actually received. But in this case, the court said no. The claimant had quite rightly beaten their Part 36 offer, and the clear consequence of that was that actually they were entitled to indemnity costs for the relevant period after that. So that's quite interesting, actually. It comes back to the issue of applications for good reasons to depart from the cost budget potentially. Now, the practical implications of this, this is actually slide 8 now, if you're following on the slides of my PowerPoint. Well, the practical implications of this is that unfortunately it causes difficulty. It reduces the certainty. The point of the Part 36 was that when it first came out, a lot of fanfare was made about it being a self-contained procedural code. It gave certainty about offers, accepting offers, and provided a lot more certainty about what happened when parties beat their offers and what the court would award. But the increased discretion being given in these cases actually simply leads to less certainty about what will happen in regard to these offers. For example, I actually currently have an appeal going through where we are arguing and dealing with the case of MR versus Commissioner of Police. In this trial, the claimant was awarded nominal damages, but they actually succeeded in beating a Part 36 offer that they'd made shortly before trial for in effect, nominal damage amount of a slightly higher, a few more pounds, shall I say. But again, seeking their reasonable costs. So the problem here is, and this is, I think, the issue, that it opens up the CPR to abuse. If the court were to decide that offers for nil damages or £1 damages are acceptable, then surely any claimant who realises as they proceed towards trial that their case actually is likely to fail and they won't receive any damages, can they then just make a Part 36 offer for nil damages? Obviously, the consequence of that is that if the defendant wants to accept that Part 36 offer, under Part 36, they then have to pay all of the claimant's costs. So this, in a way, I would say potentially is an abuse of Part 36. Unless, of course, you look at the particular facts of the case. And the important part here is that in the case of MR, there was an equally important alternative part to the claim. It wasn't just about damages. It was about acknowledging that he had been unlawfully arrested. It was about accepting breach of liability from the police. And so in this case, whilst he did give up all damages, there's still a valid reason for going to trial. So I don't think this case of MR will apply to normal contract, say, or personal injury claims, unless it's important for a finding of fault or for determination to be made in addition to the damages. Right. Now I'm going to move on to looking at relief from sanctions. I'm just going to have to go through an example here. I'm involved in many of these last year. It's, I think, very common, particularly with the problems of the COVID-19 and getting budgets in on time. So I just wanted to work through this and just discuss a couple of cases and how best to deal with these if you're a claimant or defendant, whether you're the defaulting party or the opposing party. Because obviously, if you are successful, and I was successful a couple of times last year, in limiting parties just their court fees. One of them, they had a cost budget of over £140,000. And if you can do that to a party and limit them to just court fees, it puts a great deal more pressure on them to put in a very reasonable offer and try and settle. So it's a very important tactical advantage for both parties dealing with this. So just looking then at the case of Manchester Shipping. Now, if you're the defaulting party, you want to be very confident whether or not you fall into this factual matrix, if I can call it that. Because if you don't fall into it, then you should follow CPR 3.9. Now, if you do fall into it, then you want to send a letter to the other party, telling them very swiftly that you believe that you're not in default and that you invoke the unless provision in the CCMC. Now, just very briefly, obviously, looking at this, if you are not, then obviously you want to make an application under 3.9. And 3.9, just in case you haven't got it before you, obviously, is that on an application for relief from sanctions imposed for failure to comply with rules, practice directions, or court orders, the court will consider all the circumstances of the case so as to deal with it justly, including the need for litigation to be conducted efficiently and at proportionate cost, to enforce compliance with rules, practices, and orders. And it also makes quite clear that an application for relief must be supported by evidence. So what you would need to do is put in an application with a proper witness statement explaining clearly the three-part test requirements in Denton and White. So was there a significant breach? If you're going to be bold and say there was no significant breach, then please explain clearly why there was no significant breach. Perhaps it was just for a very short period of time. It's not imperiled any hearings, etc. When dealing with a good reason, be very clear on that. And again, just be honest and frank. If it's an error by the solicitor, it is best, I believe in my experience, just to say so. Say to the judge, well, it was completely my fault. I accept that's not necessarily a good reason. Then go on to say, in the third limit test, why it would be just and equitable to allow the relief from sanction. And that's where you need to set out quite clearly an explanation of what's happened, what will happen, and you want to try and say that there won't be any delays upon any significant court hearings, in particular the trial. If you are thinking of the Manchester Shipping case and trying to argue that you don't need to put in an application, then these are some of the health warnings you need to consider. Basically, there is a lot of case law which would suggest that you shouldn't necessarily follow the Manchester Shipping case. One example, which is a very strict example, is that in Lakini and other versus Mahmood. Now, this is a 2017 High Court case. You'll find this on my slide number 10. This was a Chancery matter. And what happened in this case is that a cost budget was put in 1 day late. So it was still filed 20 days before the CCMC. The parties were able to consider each other's budgets. They exchanged their precedent R. They provided their cost budget comparison. But the judge refused them permission for relief, and he didn't allow them to rely upon the cost budget. And the Court of Appeal upheld that decision. And the important part of this is actually in paragraph 9. which explains the reasoning for this. Because again, this seems actually equally extremely harsh. What they said was that the application was not advanced in a manner calculated to optimize the chance of success. And they set out 4 explanations for this and 4 reasonings. Now, the first was that the application was not made in a timely manner or immediately after the default. It was actually made at the last minute just before the hearing. That leads into the second issue, was that the late service of the application precluded and prevented the other side from serving evidence in response or having a reasonable time in which to consider whether or not they were going to oppose the application for relief. This then feeds into the third reason, which is that they had a 45-minute cost budget hearing, which was turned into a relief hearing. And so they lost their cost budget hearing. Inevitably, again, this comes into the fourth matter, which is that the dispute over relief from sanctions had the potential to disrupt agreement of the cost budgets. So all those 4 things there, which really flow from the fact that an application for relief was put in at the last minute before the hearing, resulted in a cost budget that was only 1 day late being disallowed. Now, another case, not quite so severe, but again, shows you that the view of the courts generally. This is Jamadar versus Bradford Teaching Hospitals, NHS Foundation Trust. It's a 2016 Court of Appeal case where a district judge had refused to consider a cost budget produced on the day of the CCMC, and they'd made an order under CPR 314, which was that they were limited to the applicable court fees. And again, the Court of Appeal approved the district judge's decision, and they highlighted here that the breach would result in a second cost management hearing at a later date. That would add to the costs and lengthen litigation, and it would make additional demands on the resources of the court. That's set out in paragraph 38. So quite clear as to the reasons for refusing the application for relief. And another more recent one, this is a case of BMCE, Bank International versus Phoenix, 2018 High Court case. Again, this is an example of what not to do. The defaulting party only filed their cost budget 8 days before the CCMC. There was no budget discussion report filed. It was not possible to deal with the defendant's cost budget. The defendant then produced a witness statement and a skeleton argument for relief from sanctions, but they were only received on the morning of the CCMC, which is just guaranteed to annoy the judge. And what was said in this case by the judge was that this was an archetypical case where it would not be appropriate to grant relief from sanctions. There was a serious breach without good reason, followed by a very late application to seek relief, and a consideration of all the circumstances demonstrated it was not an appropriate case for relief. And they went on to say that it's important in all divisions of the High Court, not least the business and property courts, that parties comply with the rules, practice, directions and orders so that litigation can be conducted in an efficient manner and at proportionate costs. What the judge did say was that this means there may be cases where relief would obviously be granted and no point is rightly taken. The rules, directions and practice orders are there to be observed for good reason. So suggesting that if a good application is put in promptly, then they would not expect the other party to oppose it unreasonably. But equally, the judge then went on to say that if there is a failure to comply, then an application for relief and sanctions should be made promptly, supported with evidence, after which we considered in accordance with 3.9. So, having considered these, what would a party do? If you're the defaulting party, as I said before, you put in an application, you do it very promptly, you also exchange your precedent R, you produce a budget comparison. You try to agree as much as possible of the cost budgets and indeed directions, because what you want to do, obviously, is to put the court in the best position to have enough time to deal with your application. And that, so the court doesn't run out of time, that it doesn't have to adjourn it off, and with an increased threat that there will be a severe sanction. Conversely, if you're the party opposing this, well, I suppose first we want to consider whether this fits with the factual matrix of the Manchester shipping case. And even if it does, then you will probably inform the other side that you expect them to put an application for relief under 3.9, that you will oppose it, and that you want to see in the application for relief a full and proper explanation for the breach. If their application for relief is late, you want to highlight that. You want to flag up that it's giving you a lack of time to take proper instructions, and that there will therefore be now a lack of time, potentially also to deal with the application within the CCMC. And certainly if there's an adjournment or a second hearing, then you want to refer to these above cases to try and urge and persuade the court to disallow and not rely upon the cost budget and implement CPR 314. Well, I hope that's been helpful for you. One thing perhaps I would just want to add on, because I'm not sure how many solicitors are aware of this, is that if you are unfortunate enough to be sanctioned under 314 and you have got your cost budget just reduced to the court fees, don't despair, because there are ways to get out of it. And I touched upon this before. There is in fact a mechanism under CPR 36, and it's 36.23, which I think lots of solicitors don't know about. But under 36.23, if you do put in a Part 36 offer and you are successful on it, you can actually still recover 50% of your costs from the expiry of the relevant period, even though you have been sanctioned under 314. So if this does happen to you, I would advise you to go and think very carefully about the value of the case and put in a very well pitched, maybe generous Part 36 offer, so that should it continue all the way to trial, you will have a good chance of recovering 50% of your costs regardless.